afternoon and welcome. We're pleased to have you with us today. We have 4 cases on the afternoon docket. We will hear them in the order in which they appear on the docket. Let me remind counsel that each side has a total of 15 minutes for argument, and that applies whether there's one or multiple attorneys who are arguing one side of the case. The appellants have the right to reserve up to 5 of those 15 minutes for rebuttal. When you get to the podium, after you've introduced yourself, let us know how many minutes you'd like to reserve, and the clock will be programmed accordingly. Are there any announcements or introductions? Hearing none, please call the first case.
Patrick Kevin Morris et al. Versus Jeffrey M. Foster et al.
Good afternoon. I'm Pat Young and represent the Morris Morgan Trust.
Good
and
afternoon.
If agreeable, since that's a mouthful, I'll just call them the trust. The trust filed an action for declaratory judgment.
Do you want to save any time for rebuttal?
Yes, sir. I'm sorry. 3 minutes, please.
3 minutes.
The trust filed a petition for declaratory judgment to determine the rights of the parties under a contract made between a prior owner of their property and the Beechwood Plantation HOA. It involved the use of Parshot Lane. The trust owns Lot 19, which was one neighbor beside it was Lot 18, which is the Fosters, one of the original defendants, and on the other side was the Profiteers, Lot number 20. Across Parshot Lane, the trust owned Lot 21 and Lot 22. They've got a barn and fields on them. So Parshot runs up the middle of their 3 lots. The Foster's property has a driveway on a road below. This is pretty high elevation, rock main. The Profiteers, the third property that touches the border of Parshot, goes out Bailey Road. So the only house that's ever used Parshot Lane is Lot 19. The dispute arose because the Fosters in Lot 18 bought land behind it that borders Lot 22, the trust property, but it's not in the subdivision. And that's when the first request was made to access Parshot by the Fosters because it had had a gate on it for some time. And the court originally ordered us to give the gate code to the association, which was done. So everybody in the association, there's only 22 lots, 3 are combined, 2 others, so there's only 19 total votes. They're big acreage lots, but there's only a few members.
So everyone in owning property in the HOA has the gate code and they can come and go.
Well, the gate has since been ordered down, but yes, we complied with that court order and provided it.
Okay.
We believe the trial court erred. First of all, she would not continue the motion. There were 4 motions filed. I filed a motion to compel discovery from the HOA. The trust had a motion for partial summary judgment because the Fosters claimed we did not include indispensable parties. Our position was the HOA handles the business of the association. I don't need, other than the Fosters, to name individual members. She declined to rule on that. She took both motions of the Fosters and the HOA under advisement, which was to tell us a Parshot agreement didn't provide rights we thought it did, and to make us take down gates, and that the 2018 amendment to the covenants, conditions, and restrictions of the HOA superseded or negated the Parshot agreement, the road agreement that we were claiming rights under. That agreement started, this was a fairly new property. It transferred from the declarant, the builder, developer, to the members in a transitory meeting that was in December of 2015. Now, a prior owner of Lot 19 in 21 had already begun a letter of intent to remove those 2 lots. They wanted to buy the third lot, Lot 22, and be removed from the association. That was in working with the developer it was over how many dues they were paying on lots. And on October 5th, with the HOA, the members that had not yet become control of the HOA, a letter of intent, which was Exhibit G to the petition, was drafted. At the organizational meeting on December 14 of 2015, Exhibit H to the petition, the first order of business was, we'll vote on these issues in January. The Babiock letter of intent, which was a Lot 19 owner, 2015 letter of intent. Poll taken, approval in January, formally effective. Well, it took some time, but the HOA produced what is called letter agreement, Brian and Jan Babiock, lots 19, 21, and 22, dated March 12 of 17. It wasn't signed until April of 17. And this is the agreement we say.
It's my understanding that there's no disagreement as to the execution of these agreements and the approval by the HOA. The question is, what is the intent or what is the meaning of what the letter agreement says?
We call it, I believe it's a contract, Your Honor, and I don't know that an amendment to the CCRs after this agreement was signed can negate a contract between two parties. Under the governing documents, both at the time this was entered into and the amendment in 18, the board has the right to manage the affairs of the association on behalf of all its members. It takes two board members to sign a contract, which it has the right to do, and we've quoted all those sections. And this was in fact signed by two board members, one who is still the president of the board, and one abstained and another member signed it. And it states in there, in this agreement, as formalization of the homeowner endorsed letter of intent attached from October 2015, the following is agreed to by the undersigned, modifying the LOI. These basic terms have been in practice throughout 2016 and now will be officially effective for 2017 and beyond. What it states is those three lots are combined and paying one set of dues, but they're going to be exempt from any road work on the other two. These are all private roads, three of them, Rock Main, Mystico, and then Parshot. They're going to be exempt from paying for any other roads, but they're taking over 100% of the maintenance of Parshot Lane. They are doing the road maintenance, any mowing and landscaping. They have to take care of the water system that only serves Parshot Lane and all the fencing along Parshot Lane. Now, common lines between Lot 18 and my lot, they share that between 19 and the Fosters. They would share the common line maintenance, but everything on Parshot became the responsibility of the Lot 19 owner in this agreement. It goes on to say maintenance to lots 18 and 20, which are the two neighbors of Lot 19 that share a sideline, will be granted as needed. That implies they're the only parties that have access, and that's for maintenance as necessary. It says, the next bullet point, all other HOA covenants decisions will apply accordingly. So if it isn't addressed in this, we're bound by the covenants, conditions, and restrictions. But this removes access to the membership other than maintenance access granted to lots 18 and 20 beside lot 19. Both of them have driveways somewhere else. And that's been how this operated up until the purchase by the Fosters of unrelated land that made them want to come up and use Parshot more and take the gate down.
Well, doesn't part of the covenants and restrictions say that the applicable private access road common gates for purposes of security and restricting public access, that's available to all members of the HOA, all residents?
It does say that. It also says, upon unanimous agreement of all the owners whose lots are serviced by particular private access, there may be erected a private access road common gate for the purpose of security and restricting public access. So
But are those gates, if constructed, not required to be accessible still by everyone in the HOA?
Correct. But unless you read the Parshot agreement as saying maintenance access to lots 18 and 20 will be granted as needed, meaning they don't have it every day.
So that's the only thing in the Parshot agreement that you are basing your allegation on, that Parshot cannot be accessed by anyone else in the HOA. Is that correct?
That is what we believe was intended, but again, there was no discovery allowed.
But there's nothing else in the Parshot agreement that addresses access to Parshot other
No.
than what you just read?
No, ma'am. It's really, in my mind, a poorly drafted agreement in any event, which we all know about. But it does say all other covenants will apply. So even if that's the case, they're the only home serviced that driveway to use Parshot. We take the position in any event they should be able to have a gate aesthetically approved by the HOA and then provide access code to the HOA members. The court ruled that members should be cautioned to use it grudgingly and not give it to all their friends and people because there's no other house that accesses their home from that road. So it's sort of like, let's just go over there and see what they're doing. There's not any immediate need. There's supposed to be hiking trails. They've never really been developed. Up until these rulings, there has never been traffic on Parshot. Now, there's more than should be, mostly I think because people are curious about what the trust owner is doing. So, but that is where we are. We think it is a contract that cannot be unilaterally changed. There's financial detriment. The Lot 19 owner, and has continued under the trust ownership, has paid every inch of maintenance. If this is going to be unfettered access by others, if the road is damaged, and it has been, how does that equate out financially consistent with the agreement that we've got 100% of obligation for that road, all the maintenance, all the mowing, all the landscaping, and yet suddenly, if this is of no effect, we're paying 100% of something that the HOA is relieved of. That doesn't seem equitable, and I don't think
Well,
a
you
change.
did get in return relief from paying for the other
Yes, sir. But
roads.
it's been used, the practical effect of this agreement is it's been used privately by the Lot 19 owner. Suddenly, if there's traffic and wear and tear, these are private roads for a reason. They're not built to a public road standard. It creates a hardship for one party to bear 100% of the maintenance.
But didn't the owner agree to access from for the other HOA people?
We were told we had to provide the gate code, so we did. Then it went further, and after the court ruled on the motions for summary judgment, because Lot 18, the Fosters, which use Rock Main, and the profiteers who've never had a dog in this fight use Bailey, that we have to take the gate down because all three properties did not say we want a gate. And I take issue with that as well.
All right, thank you, Ms. Young. We'll
Thank
hear
you.
from you further on rebuttal.
Thank you.
I understand the two of you will be sharing your time.
Yes, Your Honor.
Very good. How much time will you get?
7.5 minutes, Your Honor.
Okay, very good. And good afternoon.
Good afternoon, Your Honor, Your Honors. My name is Ryan Pratt. Myself and my co-counsel Gavin Dwyer is here. We represent the appellees, co-appellees, Beechwood Plantation Homeowners Association, and I'll refer to the Beechwood Plantation as the HOA for ease. Thank you for having us today. The prime issue in this case is this: does the trust have authority to erect a private security gate on Parshot Lane, a private HOA road? And that answer is a resounding no, for three reasons. The first, the trust never submitted an application for the installation as required by the association amended and restated Declaration of Covenants, Conditions, and Restrictions. The second reason, the trust did not seek permission from lots 18, the Fosters, and lot 20, the Profiteers, whose lots are serviced by that road. And the third, reason is that they were required under the CCRs to provide access to all members of the HOA, no matter if the lot is serviced by Parshot or not. It is undisputed that the trust never applied nor received permission from the Architectural Review Committee, or the HOA, to erect a permanent security gate that blocks access to their fellow members of the association. It is undisputed that the trust never sought permission from the Fosters nor the profiteers whose lots are serviced by Parshot Lane as required in the governing documents. It is also undisputed that the trust became owners of lots 19 and 22 on July 19, 2021, and took those lots subject to the CCRs.
What is stopping the HOA from now doing what arguably it should have done a few years ago? The things that you mentioned that have not been done. What is preventing them from doing it now?
They could. If they followed the CCRs, applied to the ARC, and the ARC approved the gate, they would also have to seek permission from lots 18 and 20 to erect a security gate.
They being the owners of lot 19.
The trust, correct. And, but they would still be obligated to provide access to all members of the association to walk that street on a daily stroll or walk their dog or whatever.
Well, Ms. Young says that while the gate was up, they provided the code to all HOA members as ordered by the court.
Right. It was by order of the court. They didn't voluntarily abide by the CCNRs.
But if that order stays in effect as a permanent injunction or what have you, doesn't that give everybody access?
That would, but the lots 20 and lot 18 would also have to consent to the security gate being there. So it's a two-pronged analysis. The ARC has to approve it, and the lot owners have to agree to it. Now, the trust references the Parshot agreement, and generally speaking, the Parshot agreement is a maintenance and responsibilities agreement that you're exempt from HOA dues as long as you provide maintenance for Parshot Lane. That remove their obligation, as the court noted, of maintaining other roads in the HOA. So it's a mutually beneficial agreement between the HOA and the trust, and for purposes of the summary judgment motion, we agreed to the validity of the Parshot agreement. And if you look at the Parshot agreement, it specifically cites to what provisions in the CCRs that are being the consideration. It's Articles 4, Section 4.1, Article 4, Section 4.2, and Article 4, Section 4.8. Nowhere in the Parshot agreement does it modify or change any provision regarding the gates and the procedures to erect a security gate or follow the procedures of gaining consent from lots 18 and 20. The primary task of this court is to determine the intention of the parties by the plain and ordinary meaning of the language in the restrictive covenants. That's case law, well-known case law in Tennessee. And if you look at the Parshot agreement, nowhere in the Parshot agreement does it say, or does it vest exclusive ownership of that road to the trust.
Doesn't it say exclusive use?
It does not say exclusive use, Your Honor. Nowhere in the Parshot agreement does it say exclusive, only, or sole use of that road. Nowhere in the agreement, and the trial court noted that as well. And so when looking at the plain and ordinary,
Well, hold on.
okay,
The subdivision plat contained a special note stating lots 18 and 19 may take exclusive access from Parshot Lane, close quote.
they may, but they're not required to.
Well, but it says exclusive access.
If lot 18 or 20 wanted to create a driveway on Parshot Lane, they would have to submit an application with the ARC, just like anyone else would, and the HOA is inclined to approve it because because it's a service road by which the par shot runs through 18 and 20. So just because they're not using it currently as an entryway doesn't mean that they're prohibited from doing it. Nothing, as I said, the par shot agreement, nothing in the par shot agreement gives exclusive access to the trust. And for the trust to interpret the par shot agreement to grant that exclusive access would be an overreach and would deviate from the plain and ordinary meaning and intent of the par shot agreement, which was intended solely for you don't have to pay assessments in exchange if you maintain the road.
So it didn't say anything about access for other members of the HOA?
No. It was silent. And silence doesn't create ambiguity. And in fact, it does, as the court noted, it does talk about maintenance of 18 and 20, but hypothetically, they could erect a security gate. And so the par shot agreement, by referencing the maintenance, is saying, hey, not only do the members have access to par shot lane, but we also have to have access for maintenance personnel. And so that's the reference.
So it does allow members to have access?
No, the par shot agreement.
You just said that.
The par shot agreement is silent on any.
Okay, what allows members to have access? The HOA CNRs?
Correct.
Okay.
And I'll reserve the rest of my time for any other questions that the court has.
All right, thank you. Good afternoon.
Good afternoon, Your Honors. Kathleen Robson Gordon on behalf of Foster's. My co-counsel, Huntley Gordon, is also here. I don't want to repeat things that Mr. Pratt has said, but so we believe
And are
that
your clients the Fosters?
that's correct. We're the Fosters. They own lot 18, which is accessed also by Parshot Lane. They have a driveway that goes out to another one. We've walked the property. Parshot Lane goes to the back of our client's property, so it does service it. We believe the court ruled correctly on summary judgment, there not being a genuine issue of material fact, and I think for actually 5 reasons. Gates are not mentioned at all in the Parshot agreement. There's nothing in the Parshot agreement, which we stipulated to as an existing contract for the purpose of summary judgment, not mentioned at all. The Parshot agreement, on the other hand, specifically says that it will be subject to the other covenants and conditions of the CCRs. That agreement was executed in 2017. The CCRs were amended and restated. The language remained the same on the amendment and restatement as to the relevant part, which is been alluded to a couple times here, but it's common gates and entrances upon the unanimous agreement of all of the members who own lots which are serviced by a particular private road. There may be erected gates. They have to, give everybody the codes. These types of things has to be approved by the ARC. The trust clients purchased the property, didn't talk to anyone, just erected a locked gate, and then sued my clients. I'm not sure why they didn't sue the profiteers or the other HOA members, but they just picked my clients and the HOA itself to sue. So the third would be that the 2018 amended and restated CCRs make no reference at all to the Parshot agreement. The fourth, they didn't ask, I guess they neither asked my clients for permission. We weren't even asked to agree to it. They didn't go to the review architectural committee at all. And finally, per both my client's deeds and the trust's deed, they're subject to the CCRs, which everybody would expect. They're also subject to the plat, and the special note that was just mentioned, I believe, by Justice Bennett, on the plat says my client's lot and their client's lot may take exclusive use of their property from Parshot Lane, which has been alleged to be ambiguous. I don't see how it is ambiguous, but that is their deed says that. Not only that, the 2018 amended CCRs once again reference that plat. No other plats have ever been produced, and that is a very clear special note on there. So I don't know that I have anything to add that Mr. Pratt has not, and unless you have questions for me.
There was a discovery dispute. To what extent would discovery matter or not?
Yes, Your Honor. Okay, so that it was the trust was asking for financial records discovery from the HOA, and if this had gone further and we were we were arguing that the par shot agreement isn't valid. That's part of our complaint, right? Because we didn't sign it, the board overstepped their authority if it did limit access, these types of things. But for purposes of summary judgment, we all stipulated, okay, the par shot agreement exists. You still can't do this. So we think the trial court correctly ruled that she didn't need any more information to bolster her argument that this par shot agreement existed, because we were stipulating to it for the purpose of summary judgment, and any evidence that there had been prior conversations to erectigate these types of things. If they didn't make it into the par shot agreement, they are not part of the par shot agreement. It's pretty settled in Tennessee law, and we quoted a couple cases that you can use parole evidence or extrinsic evidence to clarify context if something's ambiguous. There's nothing ambiguous in here. If this agreement had mentioned just the road, we're all just talking about the road, then maybe extrinsic evidence could be brought in so we could all agree that we were talking about par shot road. But because this was, we stipulated to the fact everything in this agreement, fine, is a contract for the purpose of summary judgment, I don't know how discovery would have helped their position at all.
So it's your position then that even if the par shot agreement exists and is valid, that's still not detrimental to your client's claim?
No, we by deed and plat and CCRs, my clients, and in fact the entire all HOA members have a right to access this road. These are multi-million-dollar huge properties. There's horse trails, there's walking trails. It's over in like Leapers Fork. By the clear language of the CCRs, which they're bound to, and which nothing in the par shot agreement modifies, everyone has access to this. And they just moved in, erected a gate, locked it, and then sued everybody.
Are there trails that one would access off Par Shot Road?
That is a question that I'm hoping the HOA attorney can answer. I don't know. I think so. All right, thank you, Your Honors.
Thank you very much. Ms. Young, your rebuttal.
Briefly, Your Honor, there are no trails off of Par Shot. The only trails shown on the plat go on the Lot 19 faces Par Shot. At the bottom of their property, which is way downhill and hits Rock Main, there's a trail cut in the corner shown on the plat, but that's nothing off of Par Shot. And that trail's not ever been developed. Briefly, parole evidence may well explain the intent of the parties, which this court would look at, any court, trial court, or this court on review.
Well, what ambiguity do you say opens up parole evidence?
The intent of what this meant was it, why would undertaking 3 roads, 19 members paying for the 3 private roads versus one taking 100% for a road, it'd be cheaper to pay your 19th share of 3 roads arguably than 100% of one, not to mention the road, the landscaping, the fencing. There was a reason this was done.
That argument would mean was it a bad deal, but that doesn't really explain what it means.
The parties to this agreement, the Babiocks, they may have shed light on it. Discovery could have shown that it didn't. How the HOA has billed all of the 19 members since this Par Shot agreement says it's been in effect, it's been in practice throughout 2016, will now be officially effective for 2017 and beyond, is who's been paying for what? Have there been charges to other members for things that the Babiock or Lot 19 didn't pay that I guess it verifies this agreement was in place.
But even with that information, how does that affect whether or not that a gate can be erected and whether others can be excluded from that road?
I think we would have to provide a gate code. I take issue with the term serviced. I don't know what that means. To me, it implies there's a driveway, or that's how you get in and out of your property, which isn't the case. This does not run through 18, 19, and 20. It's the back line of 18, 19, and 20. Because they're private roads, those 3 lots actually own to the center of the road. So, but 21 and 22 are across Parshot. But the only driveway running off Parshot is to lot 19, the trust. And if we think the trust should be allowed to put a gate up and provide the code to the HOA as directed.
All right, thank you, Ms. Young, and all 3 of you for your arguments. We'll take this matter under advisement.